Honorable Judge J. Cedric Simpson presiding.
And good morning, everyone. Court does call the case of Dexter Shops LLC versus Whiskey and Rose Tanning Studio.
Good morning, Your Honor. David Waldo appearing on behalf of Dexter Shops LLC.
I don't have anyone signed in for the tenant.
You have nobody signed in for the tenant. I do have before me a stipulation and conditional dismissal.
That's correct.
And both sides are represented by counsel, correct?
That's correct, Your Honor.
All right, very good. Then what I will do is I will sign off on that. I will enter that. And you're all set?
You have a great weekend.
You do the same, sir.
I will. Thank you, Judge.
Does call the case of DJM Land Company versus Mitchell Kish.
Good morning, Your Honor. For the record, Stuart Collis, P4953 on behalf of the plaintiff. I saw Mr. Kish's.
I think I do. Mr. Kish?
Good morning, Your Honor. Mitchell Kish here.
Good morning. All right. And what is plaintiff's claim in this case, including cost?
Your Honor, including costs, that would be $6,477.40.
All right. And sir, how are you intending on getting this paid if you believe that it's owed?
I've made a partial payment. They received a check they should be in possession of for a partial payment for it, which should be leaving me a balance near $5,800. And I should have that paid within about 7 days, next week on Friday.
Well, you're entitled to an adjournment on this, so I will adjourn this matter out. You think that you're going to have the balance paid by then?
Yes, yeah, I do.
All right, I will adjourn this to May 30th, 2025 at
1 p.m.
At 1 p.m. That is an in-person proceeding. If it's not all taken care of.
Sounds good. Thank you.
Thank you, Your Honor.
All right. Thank you. Court calls the case of Avalon Housing versus Yolanda Shepard.
Morning, Your Honor. Jillian Engen for plaintiff.
Good morning, Your Honor. Andrew Campbell, P64391 on behalf of Yolanda Shepard. Last night, Your Honor, I filed several pleadings, Judge. The matter is a little bit complicated, and I'm not sure if you would, if opposing counsel will be better to describe what's going on.
Your Honor, it's my understanding that there was a flood in the unit. And so I think that the parties are attempting to resolve this. However, my client needs to go in and complete repairs. And so we're trying to coordinate retrieval of Ms. Shepard's belongings. We're trying to figure out kind of how to move forward. But my client does need to get into the unit and ensure that, there's not going to be entry by Ms. Shepard. And so we filed the ex parte motion with that intent that the court would give authority to plaintiff to remove and secure defendant's personal property and then dispose of anything that was damaged that's in the leased premises.
And
May I
what
add? I'm sorry.
Go ahead.
Yeah, if I may, Your Honor, just to add to that a little bit. We had a 10-day meeting, Your Honor, and my client was living with a neighbor after this flood. And then May 8th, the county came in and put a tag up and locked everybody out. May 9th, opposing counsel emailed me because the day before I had emailed them asking about the case. And they sent me the pleadings and also the notice to quit and the health hazard. Now, those were served, Your Honor, just so you know, on the same date that these pleadings were filed. So I filed yesterday a motion to dismiss for lack of jurisdiction and a response to the defendant's motion, as well as an answer and affirmative defenses. we are trying to work with
What-
them.
Well,
We're not,
let's deal with the jurisdictional issue. What is your jurisdictional issue?
well, Your Honor, it's my understanding that MCL 600.5714 states a person entitled to possession of premises may, meaning it's permissible to recover possession by summary proceedings after a person holds over premises. So to hold over, you have to be served the notice to quit, the 30, if you send a 30-day notice, you got to send it, give them 30 days to comply, and then file your summons and complaint. Or in this case, they did both a 30-day TOT notice and a health hazard notice, but they sent the health hazard notice on the date of filing. And respectfully, I think that that's violating the law, because you're supposed to give them 7 days to get in. And frankly, that's hard to do so when the county has locked you out. And so the court lacks jurisdiction because the requisite requirements by the statute were not met prior to filing. And I listed all the law in my brief, Your Honor, in my motion. Ypsilanti Housing Commission versus O'Day. Plaintiff's termination notice is improper and void. And also Park Forest versus Smith, a proper termination notice is necessary for the court to have jurisdiction. And while the notice was valid in respects to perhaps the content, although we disagree with the assertions, it was not timely. It was not filed in a timely manner. And so my client never had a chance to kind of abide by the demands of the notice. And additionally, I filed a motion for discovery if the court was not going to grant it, because the fire report indicates, I'm quoting from page 1, incident type sprinkler activation, no fire, unintentional. It also states, quote, there was no fire or smoke in the building, end quote. So my client, she wasn't responsible. Apparently this sprinkler, I haven't been in the apartment because we're locked out, but it's cathedral ceilings. It's way up. My client tells me she can't even reach it with a ladder. So the sprinkler just went off and caused all this water to be ejected. She's been, and Avalon has been assisting. They did offer a hotel, but she couldn't get transportation to the kids for school, so she stayed with a neighbor. Now they're offering a hotel again, which we're grateful for, and we want to take advantage of. But my client is poor and doesn't have a lot of money and needs to be able to get a U-Haul and a storage unit. So she went to Faith in Action and should be hearing from them today.
Why are we going through all of this? It's the unit is untenable, correct?
Well, that's the conclusions they state. They're stating it's untenable, and I don't know I don't know for sure. I don't see any insurance adjusters reports. I don't see anything. There was an inch of water.
I guess I'm not even clear why we're going through this. Under paragraph 31 of the lease, the landlord wants to enter the premises to secure the premises.
Yes, but there's a couple problems with the order. And the order that they proposed, Your Honor, let me get specific. And because I've been through this before. I've been down here for 3 months, and I've seen this before. And it says, it's further ordered that plaintiff may remove and secure defendant's personal property from the leased premises. And here's the problem language. Dispose of any rubbish, trash, waste, and other water damage and or flood damaged items contained in the leased premises. That's a problem, because any maintenance person.
Then why don't you just ask that they can just that your client can look at it? I mean,
Yeah, that's what I did in my motion that I filed.
Don't interrupt me. Why are we going through all of this? They need to get into the premises. They tag the unit. They need to get into premises. Otherwise, more damage is going to occur, both to your client's property as well as to the tenant, to the unit. Doesn't make any sense to me why we're going through all of this.
I'm sorry
if the issue becomes the destruction or the disposal of property, then certainly I think council should be able to arrange that as the property is being removed, your client can be there to try to salvage what property is salvageable.
May I speak, Your Honor?
Go ahead.
I apologize for interrupting the court. Judge, there's a lot of issues in this case. If you look at my motion, my response, the problem we have is we want that, Your Honor. We asked at the 10-day meeting for opposing counsel to contact the county and get the county's schedule when they can come out and open the door for my client. And my client can then go in. Nobody can enter without the county's permission, Judge. Okay? That's what we want. But what we don't want is we don't want some maintenance person looking at the goods and saying, oh, that's water
Well, why
damage.
don't you and council get together, contact the county, and arrange a time to go down?
I agree.
What is so hard? What is so hard about that?
There's nothing hard, Judge. It's not on me to do that, Judge. It's a plaintiff's case. And we had a meeting. And I have
Counsel. Your client has property that she may want to salvage. It would seem to me that it would be in your interest to contact plaintiff's counsel, get with the county, figure out a time that the parties can go in there. It's in all parties' interest to do that. Your
Yes,
client, the landlord, everybody's interest to get into the unit, get out those items that your client that are salvageable, allow the landlord to go in, repair what's there so that further damage doesn't occur.
I agree.
It
And that's
just
why
seems
we
to
had a
me that
10-day
a
meeting.
mountain's being, all right,
I
here's
don't
what we're
understand why
gonna
I'm
do.
not seeing.
Here's what we're gonna do. I'm adjourning this to next week. Between now and next week, I'm gonna order that council get together with the county, arrange a time to go into the premises for inspection of the premises and removal of those items.
Thank you, Your Honor. And so at this time, I just want to clarify, Your Honor, you're not entering the ex parte order as drafted.
I'm not gonna enter that order. I'm gonna enter the order directing the parties to get with the county, enter to gain entry to the premises. That defendant is to remove those items that she wishes removed.
Thank you.
And then plaintiff is also able to secure the premises and stop any further waste on the premises.
Thank you, Your Honor. Two things briefly, Your Honor. We would like to reserve escrow or preserve escrow from today's date. Also, the case was filed under 657-14 1C 1i after termination of the lease pursuant to a power to terminate provided in the lease or implied by law. Obviously, we can talk about that later. I just want to have that on the record.
Well, that's why I don't see the jurisdictional issue, because I think it's properly filed pursuant to the provision in the lease, but we can argue that at another point. But I'm ordering that. And I'll set this for May 30th, 2025 at 3 p.m. That's in person.
Thank you, Your Honor. Would you like us to submit an order to the court in accordance with?
Please.
In person didn't mean I was supposed to be here. I wasn't even supposed to be here.
Thank you. Glenco Hills versus Justin Jefferson.
Jillian Engen for plaintiff.
Don't have that checked.
Justin Jefferson. There is no response. And I also should say, is it Unganchuku Nasiki? Nasiki? No response. If you'd raise your right hand, I'll let you proceed. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,494.56. Court costs are $212 for a total of $3,706.56. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. Do I have is after June 2nd?
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ issue in 10 days. Court calls case Glenco Hills versus Devonta Jackson and is it like China?
It's LaChina. You can call me China.
Say it again for me.
It's LaChina. You can call me China.
Okay, it's LaChina. Okay, I'm sorry. I didn't know where to break apart the syllables.
No,
LaChina Williams.
You got close enough.
Okay. All right. What is the claim in this case?
Your Honor, I have a balance including court costs of $1,818.50.
And LaChina, when are you gonna get that? How are you gonna get that paid?
I can get that paid by the 1st.
By the 1st?
Yes.
Okay, so here's our problem. I can adjourn it out a week, but the 1st, June rent is gonna click in.
Oh, is the 30th okay?
Can you pay it on the 30th?
Yes.
Okay. Here's what we'll do. I'll adjourn this out to May 30th, 2025 at 3 p.m. That's an in-person hearing. So can you get that paid? Can you get that balance paid, say, before noon that day?
Yes.
Okay, fantastic. Okay, so if you get it paid before noon, then what likely will happen is that plaintiff will dismiss the case. But you may want to check with them, make sure you got everything paid.
Okay.
Okay?
All right. Thank you.
Thank you. You have a great weekend.
You too. Bye-bye.
Court calls the case of Glenco Hills versus Daniel Worth.
Jillian Engen, plaintiff.
Hello.
Hello, Mr. Worth. Do you have a camera?
Yes.
Okay, I'll need you to turn that on, but while you're doing that, oh, you got it on. Okay, what is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $3,067.63.
All right, Mr. Worth, how are you intending on getting that paid?
I have a payment plan that covers next month rent, but it wouldn't be, my balance would be at 0 by next month of the 30th.
Okay, have you talked that over with your landlord?
Yeah.
Your Honor, I don't know that plaintiff is willing. I don't know if we're willing to do. I don't know if plaintiff is willing to do a COD on this one. I can ask my client.
All right, so here's what I'll do, Mr. Worth. Is there anything you can pay between now and next week?
I could do, what does next week fall on?
The 30th of May.
I could pay 1,500.
1,500 by that day?
Yeah.
Okay, so let's do this. You need to pay 1,500 by the 30th. I want that paid before noon on that date, okay?
Okay.
Then I'm going to adjourn this to May 30th, 2025 at 3 p.m. That's an in-person hearing. And then we'll see where we go from there, okay?
Could you do could you do June 2nd for the first payment?
I cannot.
Okay.
Because if you're not gonna, if you can make the payment, you need to make the payment, sir.
Okay, I'll make the payment. I could make it by June 2nd without 1,500.
All right. Well, I'll put that in the file, but I'll still need you here then on the 30th
Okay,
at 3 p.m.
Okay, thank you.
You. Glenco Hills versus Daniel Reynolds.
Jillian Engen for plaintiff.
Here.
Mr. Reynolds?
Yes.
Okay, there you are. All right. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $2,068.70.
All right, Mr. Reynolds, how are you intending on getting that paid?
So approximately $750 I could pay by Wednesday of next week, and most of that today. And then that will leave me with my normal rent for the month of May, which I can make another partial payment on May 30th, but it wouldn't be the full amount of May on May 30th. I'd need approximately a week to 2 weeks to catch that up. And then I know
All right,
I'll be
hold
due
on.
for June.
Hold on a second. You're gonna pay 750 by the 28th. That's next Wednesday.
Yes, and that'll just
All
leave
right.
me with May.
Okay, and then on the 30th, how much did you say you're gonna pay?
I'll be able to pay roughly $600.
Okay, and then $600 on the 30th. I'd like that paid to the landlord before noon.
Sure
Okay,
thing. Yes.
and then I'll adjourn this out to May 30th, 2025, 3 PM. That's in person. So, then we can see where we can go from there, okay?
Your Honor, would it be possible for an alternate viewing? I will be in Chicago on next Friday.
Okay, that's the time that I've set it in person. You could submit a form to the court requesting a Zoom hearing, and then we'll consider that.
Okay, and what is the best way to submit that? Do I go to the court or is there an electronic version I could use?
I can put my email in the chat.
You can, my coordinator will put her email in the chat, and so you can make that request directly there, okay?
All right, thank you.
Thank you. Gulfside Lakes versus Sarah Brown and Jalen Brown.
Jillian Ingram for plaintiff.
Good morning, Your Honor. I'm here.
Good morning. Your name?
Miss Sarah Brown.
You're Sarah Brown. Okay.
Yes, sir.
You got it? Okay. And what is plaintiff's claim?
Your Honor, I have a balance including court costs of $3,473.47.
All right. And ma'am, how are you intending on getting that paid?
That's not the cost that I have. I don't know if they received the $2,400 that I paid last night.
We wouldn't
Okay.
know.
Okay.
You would not have.
That would
So you
make
paid
difference.
$2,400 last night?
Yes.
Okay, so I'm gonna indicate that was the 22nd. You paid that.
Yeah.
And then,
in the
so
evening.
that leaves you about 1,000 and some change. So when were you gonna get the balance paid?
I could pay the balance by either in the evening on the 30th or early morning on the 31st.
Okay. So it looks like there may need to be a COD if you can't get it paid by noon on the 30th, is what you're telling me.
I can try. I don't want to make that promise because my money hit
Got
like
it.
different times, if that makes sense. I'm sorry.
No, that makes sense. I got you.
Because sometimes it hit earlier in the day, then it'd be in the evening. It's crazy times. I'm sorry.
Okay, all right. So here's what I'll do.
Okay.
I'll let them try to get their accounting and get your ledger all caught up. I'll adjourn this to May 30th, 2025, 3 PM. That's an in-person hearing. And then we'll try to figure out how we're gonna work it out if it's not paid by then.
Okay, can
All
I
right.
get that? May I get that balance again she has so I can minus the 2,400 from it so I'll know what I owe, if that's okay?
Yep, yes, and I have $3,473.47. You can
Okay.
also contact Melissa.
Okay.
She'll give you your-
Okay. Yeah, and I'll definitely try to have that paid before 3 o'clock on the 30th. Thank you, Your Honor.
All right.
All right.
All right. Thank you.
Uh-huh.
Gulfside Lakes versus Lakia Williams and Heron Williams.
Jillian Ingram for plaintiff.
Hello, Your Honor.
Hello. All right. And Ms. Williams, do you have a camera?
Yes, hold on.
All right. I'll need you to turn on your camera. And what is plaintiff's claim in this case?
I have a balance including court costs of $3,593.26.
All right. Ms. Williams, how are you intending on getting that paid?
So I can have about 593 next week, but I am also in the process of working with Hawk.
Okay. So you're working with Hawk?
Yes, I had an
Do you have
appointment with her
do you have an
yesterday.
appointment with them yet?
Yes, I had one yesterday at around 1
Oh,
p.m.
you did?
Mm-hmm.
Okay. They haven't indicated anything then to you?
No, what was her name? I think Alicia. She said she's
Okay.
working on it.
Okay, so here's what I'll do. I'll adjourn your case out May 30th, 2025, 3 PM. That's an in-person hearing. And hopefully we can have some news from Hawk. Try to figure it out. I suggest that you make the payment that you're gonna make so that if there's funding there, you'll be below the limit that can get paid, okay?
Yes.
All right. Okay,
Thank you, Your Honor.
thank you.
Pardon me, Judge. Could you ask
Yes.
your administrator to clarify the email address that she put in there? I've sent a question. It's a little confusing. Thank you.
Who's,
I've already answered his question.
I think she answered your question, sir.
Thank you.
Gulfside Lakes versus Alicia Sarr.
Jillian Ingham for the
She's
plaintiff.
here. Sarr?
Hello.
Hello, there you are.
Hi.
Okay. Hello. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $219.14.
$219.14.
Yes, sir.
Okay. All right, Ms. Sarr.
Yes.
When do you think you can get that paid?
So I made a payment arrangement to pay the rest of it tomorrow with the landlord.
Okay. So you're gonna have everything paid. If I adjourn it out a week, everything should be paid.
Yep.
Okay, then let me do that. I'm gonna adjourn this to May 30th, 2025 at 3 PM. That's in person. But if everything's paid, it's likely they'll dismiss the case and then you don't need to appear.
Oh, no, okay. Thank you.
Okay? All right.
Yep.
Take care. Have a
Okay.
good weekend.
Thank you too.
Court calls the case of Gulfside Lakes versus Erica Hall.
Jillian Ingham for plaintiff.
She's there she is. Hello.
Hello.
And I got it right. So, and you know what? You didn't even say, good job, Judge. You didn't say anything. I got it right. I'm just saying that because I'm proud of me. So, all right.
The
All
win.
right, Ms.
The
Hall.
win.
All right. How much is owing?
I have a balance including court costs of $2,749.29.
You said 2749?
Yes, sir.
All right. Ms. Hall, how are you intending on getting that paid?
I can have everything paid by the 13th of June, but I know that's pushing it. I can make a payment of $600 by next Friday, and I'm taking out a personal loan, but it takes a few days for that to go through.
To get through.
Yeah.
Okay, so let's do this. Pay the 600 by next week. I'll just put by the 30th. If you can pay that early in the day. And then I'll adjourn it out to May 30th, 2025 at 3 PM. That'll be in person. And you might want to contact the attorney's office, see if they said, you know, that you won't have it paid before the 13th of June to try to work something out regarding a COD or something to get that in June encompassed. Got it?
Okay.
Okay? All right.
All right.
We'll see you next week. Take care.
All right. Thank you.
Court does call the case of Gulfside Lakes versus Emmett Redwine.
Jillian Ingham for plaintiff.
Hello.
Hello, Mr. Redwine. All right. I'm doing okay. All right. How much is owing?
I have a balance including court costs of $3,009.28.
All right, Mr. Redwine, how are you intending on getting that paid?
I'm gonna pay something Friday. I'm gonna pay something Friday, then I'm gonna pay another 1,600 2 weeks after that. Then
Okay, so how much can you pay by next Friday?
I'm gonna pay $750 Friday. It's Friday.
Okay, so 750 by the 30th. It looks like something's gonna have to be worked out regarding a payment plan or something, if it can be. So then I'll adjourn this out May 30th, 2025 at 3 PM. That will be in person. And then we can see if we can get it get something worked out. Okay, Mr. Redwine?
Okay. What time?
All right. That's at 3 p.m.
Okay, thank you.
Thank you.
Bye.
Court calls the case of Gulfside Lakes versus Michelle Goebel and Marlon Goebel.
Jillian Ingen for plaintiff.
Good morning. This is Michelle Goebel.
Okay, good morning. All right, how much is owing on this account?
I have a balance including court costs of $1,643.74.
All right, Ms. Goebel, how were you intending on getting that paid?
Yes, I get paid every other Wednesday. So I was planning on doing about 600 on the 28th and then the remaining balance on Wednesday, June 11th, both before noon.
On June 11th,
Yes.
but is that that's going to include your June rent or no?
I think so. Yes, yeah.
All right, so here's what I'm going to do. You said you can pay 600 by the 28th.
Yes, sir.
All right, get that paid. I'm going to adjourn the hearing to May 30th, 2025 at 3 p.m. That's an in-person hearing. And I'd suggest that you contact plaintiff's attorney's office, see if you can work out some type of either conditional order dismissal or something regarding this case, okay?
Perfect. Thank you so much.
All right, thank you. Have a great day.
Again, you too.
Gulfside Lakes versus Mia Salvano.
Jillian Ingen for plaintiff.
I don't have her.
Mia Salvano? No response. You've been sworn. You may proceed.
Thank you, Your Honor. This is the case for non-payment of rent. Rent to retain possession is $2,784.07. Court costs are $172 for a total of $2,956.07. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Can you give me that amount again?
Yep, $2,956.07.
Got it. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days. Hamilton Crossing 2 versus Tanisha Ballard.
Jillian Ingen for plaintiff.
Do not have this bound.
Tanisha Ballard. I do not have her. You may proceed.
Thank you, Your Honor. We're actually looking to do a conditional order of dismissal with this one. I can place terms on the record, and it's going to be submitted to the court.
Okay.
Okay, so defendant may retain possession of the leased premises through the end of the lease term, provided that defendant complies with the following terms. As of May 9th, 2025, defendant has an outstanding arrearage of $2,178, includes $172 in court costs. Plaintiff shall pay the outstanding arrearage as follows. And I realize that some of these dates are before today's date. The payments have already been made in compliance with this. $300 on or before May 10th, 2025, $285 on or before the 10th of each month from June through November, and then $168 on or before December 10th, 2025. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through December 25th, 2025. And then commencing January 1st, 2026, defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right. So I see those certainly as more favorable terms than the entry of a judgment in this case. So I'll enter the COD when it's presented with those terms.
Thank you, Your Honor.
Hamilton Crossing 2 versus Joshua Myers. And is it Sheriff Myers?
Your Honor, Jillian Ingen for plaintiff, forgive me, I switched my order. This is also a conditional order of dismissal. I gave these terms I'm sorry, no, this is right. Okay, I'm sorry. Sorry, Your Honor. Okay, Jillian Ingen for plaintiff. Your Honor, we have a conditional order of dismissal for this case as well. I can place terms on the record.
Go ahead.
Thank you. Okay, defendants may retain possession of the leased premises through the end of the lease term, provided that defendants comply with the following terms. As of May 9th, 2025, defendants have an outstanding arrearage of $5,189, which includes $214 court costs. Defendants shall pay the outstanding arrearage as follows: $415 on or before May 10th, 2025, $181 on or before May 25th, 2025, $415 on or before June 10th, 2025, $415 on or before August 10th, 2025, and $260 on or before September 10th, 2025, $415 on or before October 10th, 2025, and continuing with $415 per month on the or before the 10th of each month through April 10th, 2026, $28 on or before May 10th, 2026. And then defendant shall pay monthly rent in the amount of $772 on or before the 25th of each month, commencing May 25th, 2025, and continuing through May 25th, 2026, commencing June 1st, 2026. Defendant shall pay monthly rent timely. Defendant shall comply with the terms of the lease.
All right.
So,
And I do see those terms as being more favorable than an entry of a judgment by default. So the court will enter the conditional order of dismissal.
yeah.
Court does call the case of Heron Vista Apartments versus Wilbur Burrell.
Jillian Engen for plaintiff.
You're up next. Yes.
Mr. Burrell?
Yes.
Okay, there you are. You're at our access point here.
Hello?
Hello?
Oh, can you hear me?
Yes, I can hear you. Can you
Okay.
hear me, Mr. Burrell?
Yes.
Okay. I don't have a camera on. I'm not sure why that is the case, but what is plaintiff's claim in this case?
Your Honor, I have a balance of $1,525. I also have a note from my client that Mr. Burrell is participating in the Huron Vista forgiveness plan. So I think that we should be putting together a conditional order of dismissal.
Okay. Is that your understanding, Mr. Burrell?
Yes, sir.
All right. So here's what I'm going to do, sir. I'm going to adjourn your case out to May 30th, next Friday, 2025 at 3 p.m. That's in person. So you'll actually come into the courtroom and hopefully we can have everything worked out.
Okay, yeah, because I talked to the landlord. He told me the terms and the condition to make sure I pay this 3 months and then get help from my SER, from my DHS broker.
I understand the program over there at Huron Vista. So they just have to work out the paperwork and we'll have to enter the paperwork next week. Okay?
Okay.
All right. We'll see you then.
Okay. What day you say? Next Friday at 3 o'clock?
At 3 o'clock. Yes, sir.
All right. Thank you.
Thank you. Court calls the case of Huron Vista versus Alicia Moore.
Jillian Engen for plaintiff.
Alicia Moore?
I'm just
Okay. Hello.
Hello, George.
What's your name?
Alicia Moore.
Okay, yes. Okay. All right. She's on the phone. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $3,522. I also have a note that Ms. Moore is participating in the Huron Vista forgiveness plan as well.
Okay, so Ms. Moore, what I'll need you to do is I'll need you to come down to the court next week. Hopefully we'll have a conditional order dismissal to enter that regarding the program over there at Huron Vista, okay?
Okay.
So I'm gonna set it for May 30th, 2025 at 3 p.m.
Okay.
All right, we'll see you then. Thank you.
Thank you.
Huron Vista versus Jacqueline Taylor and is it Tania Taylor?
Good morning, Justin. Good morning, Justin.
Good morning. And who I'm sorry.
Jacqueline Taylor. This is Jacqueline Taylor.
Okay, gotcha. Okay. All right. What is the claim in this case?
I have a balance including court costs of $2,194.03, and I don't have any notes regarding the forgiveness plan.
All right. Okay, Ms. Taylor, how are you intending on getting that paid?
I'm gonna pay something next week.
I had got an email about the forgiveness plan, but I didn't get the letter about it because I fell on the property. That's how I got behind in my rental payments, which I told them. I fell and then I had to take off of work because I hurt my wrist and my knee.
Okay, so, I don't know, is she eligible for the program or you don't know, counsel?
I'm sorry, I'm not sure.
Not sure?
I'm not sure. That would have to, but I will
All
ask.
right. So Ms. Taylor, have you reached out to the landlord regarding the forgiveness program or not?
I can email today. I will email today when we're done.
Perfect.
Okay, then here's what I'm gonna do. How much do you say you can pay?
500 by the 30th.
Okay, so I'll indicate that you're gonna pay 500. I'll put that by the 30th sometime. I'll adjourn this out to May 30th, 2025 at 3 p.m. That will be in person. Okay?
Okay. Okay.
And then hopefully you'll email them and hopefully we can work something out on that date, all right?
Okay, thank you so much.
All right, thank you. Have a good weekend.
You as well.
Heron Vista versus Rodney Taylor.
I have Jillian Engen for plaintiff.
He's here. Oh, there he is. Mr. Taylor, I'll need a camera, sir. And how much is plaintiff's claim?
I have a balance of $2,223, and Mr. Taylor is participating in the forgiveness plan.
Okay, Mr. Taylor, is that correct?
That's correct. I'm trying to turn my camera on. I can't turn it on. I'm having some problems up here.
Okay, here's what I'm gonna do. Since you're participating in that program, we'll need you here next week, May 30th, 2025, 3 p.m. in person. Let's get the paperwork together and get that all in. Okay, sir?
All right, no problem.
Okay, thank you. Oh, see, you got on just at the last minute. Now I know on the 30th who I'm looking for. Your camera's working. You got it. All right?
Yes, sir.
All right, you take care. You have a good weekend.
You too.
Heron Vista versus, is it Charkeisha Roberts?
Jillian Engen for plaintiff.
Charkeisha Roberts, she's not here. You may proceed if you'd like.
Thank you, Your Honor. I am going to take a default judgment. I have rent to retain possession of $2,816. Court costs are $176 for a total of $2,992. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. And Your Honor, for the record, Ms. Roberts had indicated that she wished to participate in the forgiveness plan. If she does end up, we'll prepare a COD that sets aside the default judgment.
Got it. Okay. Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Heron Vista Apartments versus Moesha Harrison.
Jillian Engen for plaintiff.
Moesha Harrison, not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $2,230. Court costs are $176 for a total of, of $2,406. Plaintiff is requesting a default judgment with the writ to issue for possession only with the writ to issue after 10 days. And also, if Ms. Harrison does agree to, she has indicated she wants to participate in the forgiveness plan. If I'm sorry, my words are, I haven't had enough coffee today.
Gotcha.
We'll
set aside the default and enter that.
Yes, sir. Thank you.
Okay. Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ to issue in 10 days. Heron Vista versus Shinar McGraw.
Jillian Engen for plaintiff.
McGraw, no response.
Thank you, Your Honor. This is a case for non-payment of rent. I have rent to retain possession of $49. Court costs are $176 for a total of $225. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, Redemption amount in the amount requested with a writ issued in 10 days, no writ without a hearing.
Thank you.
Court does call the case of Heron Vista versus Danielle Davis.
Jillian Engen for plaintiff.
Danielle Davis. They are not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,346. Court cost of $176 for a total of $3,522. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days. However, if Ms. Davis does agree to enter into the forgiveness program and enters a COD, we will set aside the default in the COD.
All right. Judgment to the plaintiff. That is by default. Possession redemption amount is in the amount requested with a writ to issue in 10 days. Evergreen Apartments versus Abraham Hack.
Hello, Your Honor.
Okay. All right, Mr. Hack, he's got his camera on.
Hello.
Right. Hello. All right. How much is owing on this guy?
I have a balance including court costs of $2,823.88. Your Honor, I also do want to note that Mr. Hack has provided a notice to vacate for the end of his lease on June 15th. And so if this case continues till June 15th, we will likely, and Mr. Hack moves out, we will likely end up dismissing.
Is that correct? Is all of that correct, sir?
Yeah, it looks like it's all correct from what I got on the paper.
Okay. Are you gonna be able to make a payment before the 30th?
Yes. I should be getting my last paycheck from my previous job before that.
Do you know how much you can pay by the 30th?
Unfortunately I'm locked out of my Alti-Pro that tells me how much I'm gonna be paid on the 30th. So I don't have an actual estimation of how much, but I'm trying to save up as much as I can to pay as much as I can, Your Honor.
Okay, all right. I'll adjourn this out May 30th, 2025, 3 p.m. That's in person. All right?
Okay, just because I'm a little bit slower, can I just the total cost of what I owe just one more time in person at 3 p.m.
The total amount that they claim is owed is $2,823.80. Was that 88 cents?
88, yes, Your Honor.
And then I was supposed to show up 3 p.m. At what was the address? Is it on the paper that I received at all?
Yes, the court address is 4133 Washington.
4133 Washington.
Right up by the sheriff's department. Okay.
Okay.
All right.
Thank you, Your Honor.
Thank you, sir.
Am I good?
Evergreen Apartments versus Idris Williams. You're all set. Sure.
Jillian Engen for plaintiff.
And Mohammed Al-Duwasi.
How's it going?
All right. Who is this?
Idris.
William, how you doing, Idris?
How you doing?
I'm doing well. All right. How much is owing on this case?
I have a balance including court costs of $1,989.60.
All right. And Sarah, how is that going to get paid?
Oh, both myself and my brother, we both recently started brand new jobs. I graduated last month. You wish me a happy birthday and graduation present. I got that all paid up and everything. That previous one paid up. It's just catching up on this 1 month that we're behind now. So I'm literally outside of my job the job. I'm signing paperwork for my new job. Like I was supposed to be here at 9 o'clock. I already went inside and told them I'm going to be a little late. And my brother, he started a new job last week, tiling floors. So he's getting paid a decent amount now, and I'll be getting paid $23 an hour. So it's literally just getting that handled out. We're both still working our other job as well at night at the restaurant in Ann Arbor. So literally it's just trying to get caught up with that 1 month that we are behind. And it was like 1 month and like 200. Yeah.
All right, let's do this. Let's do this before you lose that job that you haven't started yet. I'm going to adjourn. I'm gonna adjourn it out to May 30th, 2025 at 3 p.m. All right, that's an
Yeah.
in-person hearing. I'm gonna suggest that you contact, on your paperwork, you'll see the attorney's office number. Call them and see if you can work something out regarding this back balance. Okay?
Sounds good. Yeah, no, like next month, everything should be cleared up. It's just because like I said, I graduated, you know, the whole situation. So literally it's just trying to play catch up. So I really appreciate it.
Like I said, well, congratulations on the graduation. Get in
Thank you.
there, get that job, and
Yeah.
let's see if we can get it all worked out by next week. All right,
Yeah, I'm
my
using this
friend?
degree to work. All right, have a nice one.
All right.
All
You
right.
take care.
Thank you, too.
Evergreen Apartments versus Walter Herrera and Daniel Alvarado and Randall Romero.
Jillian Engen for plaintiff.
Any of those individuals present? Herrera, Alvarado, Romero. Nobody's present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,611.86. Court costs are $256 for a total of $3,867.86. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Evergreen Apartments versus Daryl Simpson, no relation.
Jillian Engen for plaintiff.
Daryl Simpson, not here. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,592.04. Court costs are $172 for a total of $1,764.04. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Evergreen Apartments versus Denasia Hamilton.
Jillian Engen for plaintiff.
Hamilton,
morning,
oh,
Your
there
Honor.
she is. Good morning. All right, how much is plaintiff claiming is owed?
I have a balance including court costs of $2,084.66.
All right, Ms. Hamilton, how are you intending on getting that paid?
I contacted my caseworker from DHS. I'm just waiting to hear back. And then I also have some other organizations that I'm waiting to hear back so they can put together and see if they're gonna help pay.
All right. So have you filed for an SER through DHHS?
Yes.
Okay, so what I would need you to do, I'm going to adjourn this case out May 30th, 2025 at 3 p.m. That's in person. There's a form that came with your packet notifying you of this hearing. That's called a rental assistance form. You'll have to file that with the court by next Wednesday and put your
Okay.
tracking number on that form, okay?
Okay.
Your
Okay, if
Honor.
you can't find that paperwork, you can use the QR code on the screen, or you can call our clerk's office and they'll be more than happy to give you a copy.
Okay.
Your Honor.
All right? Yes.
If I may, I have a note from my client that Ms. Hamilton's SER application was denied. I just wanted to know if she's filed a new one or if she's gonna reapply.
Yeah, I filed a new one
Okay.
as of last night.
Okay.
Got it. Okay. All right, so get that information down to the court and then we'll see you next week at 3.
Okay, thank you.
Thank you. Court does call the case of Evergreen Apartments versus Kayla Smith.
Jillian Engen for plaintiff.
Smith? Hello? I think she unmuted. Kayla Smith? Can't hear you, nor can I see you. You'll need to turn on your camera. Not getting a response.
I'll let her know.
Okay. Oh, now there she is. All right, Ms. Smith, can you hear me? Okay. I can't hear you. I can see you now, but I can't hear you. All right, Ms. Smith, do this for me. Can you hear me? Nod your head if you can hear me. All right. Sign off and then sign back in. Okay, and let's see if that'll correct the problem. I'll pass your case. Evergreen Apartments versus John Hudson.
Jillian Engen for plaintiff.
Hello?
Hello, Mr. Hudson. How are you, sir?
I'm doing pretty good. Yourself?
I'm okay, I think. All
Yeah.
right. Okay, how much is owing on Mr. Hudson's account?
I have a balance including court costs of $1,291.
All right. And Mr. Hudson, how are you intending on getting that paid?
I'm intending on getting that paid by next Friday.
Okay, so you're gonna get the balance paid by the 30th. Can you get that paid before noon on the 30th?
Yes, sir.
All right, so I'm gonna put that here that you're gonna pay the balance. If you get it paid and make sure everything is paid on your account, it's likely they'll dismiss your case. Okay?
Okay, cool.
So, but I'm gonna adjourn it to May 30th, 2025, 3 p.m. If it's not paid, you need to be here in person, okay?
Okay, sounds nice.
All right, take care. Have a good weekend.
All right, you too. Thank you.
Evergreen Apartments versus Nelsa. Is it Nieves Montez?
Yes.
Montanez. I'm sorry.
Jillian Engen for plaintiff.
Hello. Oh, there she is. Okay. All right. And how much is owing on this?
I have a balance including court costs of $3,705.12.
All right. Ma'am, how are you intending on getting this paid?
I told him I was gonna pay some on the first, and then SOS was gonna help me with the rest of it. But first, I have to pay a certain amount on the first.
I'm sorry. Say that again for me.
I told her I was gonna pay a certain amount on the first, and then SOS will help me with the rest because I had to pay a certain balance for SOS to help me with the rest of it.
All right. So you got to get down below the 3,000?
Yes.
Is that what you're looking? Okay, but if that happens on the first, your new rent kicks in, your June rent kicks in.
Yeah, she told me that yesterday.
Okay. So are you gonna try to get everything paid by then? Or
Yes.
all right, let's do this. I'm going to adjourn it out 1 week, the 30th, 2025 at 3 p.m. That's in person. And whatever you can get paid before that date, let's try to get that paid and also try to figure out exactly where Hawk may be or SOS would be with you on this case,
Did you say
okay?
the 30th?
I'm sorry?
Did you say the 30th?
Yes, ma'am.
I don't get paid until the first. That's why I told her the first.
No, I understand that,
Okay.
but we got to try to figure out, you get a 1 week adjournment, but we got to figure out how to do that. And on the first, your June rent clicks in.
All right.
And I have that amount for the record. It's going to be 5,000. The total will be $5,388.17. So we're looking at least $2,388.17 would need to be paid before if Hawk is paying $3,000.
Got it. Yeah. Okay. All right. Thank you, ma'am. We'll see you next week.
See you next week.
Evergreen Apartments versus Keith Johnson.
Jillian Engen for plaintiff.
Keith Johnson, no response. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,176.29. Court costs are $172 for a total of $3,348.29. Your Honor, my client has indicated for Mr. Johnson that they would be willing to set aside the judgment if possession or payment is received by the second. And so I'm going to include under further orders that this judgment will be set aside if paid in full on or before June 2nd, or if defendant moves out and turns.
Vacate. All right, very good. All right, thank you. Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ issued 10 days. Court calls the case of Evergreen Apartments versus Evelyn Carter, Majesty Moyer, Myron Moyer.
Still remaining for plaintiff?
Any of
Yes,
those
I'm
folks?
here.
Okay, and when you say I'm here, who are you?
Evelyn Carter.
Thank you. All right, and how much is owing on her account?
Your Honor, this is a case for termination of tenancy.
Got it.
Tenants provided a notice to vacate that they were going to be vacating upon the person on May 4th, and they have not yet vacated.
Okay, Ms. Carter, what's your position on this?
Okay, so they told me that my lease was over on May 3rd, no, May 4th. So I signed that. I'm thinking I have to move because I got a new voucher, new size voucher. I went to RPI. RPI had already paid May's rent and said my voucher doesn't expire until May 31st. So he told me to stay there until May 31st because I was moving already on June 2nd. I already packed up, already got the DTE scheduled to be disconnected, everything. That's all I knew. I didn't know what else to do about it because RPI said that they paid them and the voucher is expiring on May 31st. And your lease doesn't terminate until May 31st on our end. So I called Swap and they just told me to go to court and see what happens with that since I'm already moving, what to do.
Okay. So what day are you gonna be out?
Okay, my voucher starts June 1st, but my moving day to my new unit will be on the 3rd of June. So I already have everything scheduled to be turned off for the 6th of June, but if I can get until the 3rd, that'll be fine.
Okay, so here's what I'll do. I won't enter a judgment today, but I'll adjourn this out to May 30th, 2025, 3 p.m. in person. And then we can figure out a move out date and everything else on that, okay?
Thank you, Your Honor.
Okay, thank you so much.
Thank you. Court recalls the case, Evergreen Apartments versus Kayla Smith.
Jillian Engen for plaintiff.
All right, I see you again, Miss Smith. Can you hear me?
I can hear you.
Okay, we can hear you. Now we did it.
Pushed to my phone.
Okay. All right.
Sorry.
What is plaintiff's claim in this case?
I have a balance including court costs of $2,902.30.
All right. And how are you going to get that paid?
I applied for SCR and I'm just waiting on a decision for that.
Okay. So how many people are in your house?
2.
2?
Yes, me and my daughter.
Okay. So just so you know, that's only going to net you about $520. Okay. If they approve it. So then we have to figure something else out. So what I'll do is I will adjourn this to May 30th, 2025, 3 p.m. That's in person. And there's a form that you'll need to file called a rental assistance form. You can either get the QR code off our screen, a copy of one came in your packet, or you can come to the court. I'll need to have that filed with the court with your tracking number, your DHS tracking number. You'll need to file that by Wednesday.
Okay.
Okay?
Okay, thank you.
Thank you.
Thank you for calling Language Line Solutions. My name is Carmen, ID number 204643, Spanish interpreter. May I please have your 4-digit access code?
Yes, our number is 1423.
1423. Oh, one moment. 1423. Thank you. I am ready for your instructions.
Can you please raise your right hand to be sworn?
Yes, one moment. There you go. I'm ready.
Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in the manner now before the court, so help you God?
I swear to the best of my ability, so help me God.
All right, thank you. And good morning, Madam Interpreter.
Good morning, Your Honor.
All right. The court does call the case of Evergreen Apartments versus Lunette Yoder and Jose Contreras.
El tribunal va a ver el caso entre Evergreen Apartments y Lunette Yoder y José Contreras.
Yes, that's right. All right.
Jillian Engen for plaintiff.
Habla Ghislaine para el demandado.
All right. And Ms. Yoder, can you state your name, please?
Señora Yoder, por favor, diga su nombre.
Hola, soy Lunette Yoder.
Hello, my name is Lunette Yoder.
And how much this plaintiff claim is owing in this case?
¿Cuánto se alega que el demandante debe en este caso?
I have a total of $2,775.48.
Aquí dice que son $2,775.48.
Ms. Yoder, how are you intending on getting this paid?
Señora Yoder, ¿cómo usted tiene pensado pagar eso?
He estado tratando de comunicarme con diferentes lugares para que me ayuden a pagarlo porque ya que soy madre soltera, pues mis recursos ahorita están muy bajas y fue como una situación que traté de ayudar a otra persona. Entonces, pues yo tengo mi otro apartamento y pues yo les había dicho que quisieran pagos, pero no me dejaron la opción. Entonces estoy tratando de pedir ayuda para ayudarme a pagarlo ya que soy madre soltera y me cuesta mucho recoger esa cantidad de dinero.
Well, I've been trying to see if I can get the money from different places. I am a single mother, and when it comes to my resources, I have little resources. A situation came up where I had to help someone, and I have another apartment, so I had asked if I could make payments, get a payment plan, but they did not allow that. So I'm waiting to see if I can get help since I am a single mother and I just don't have all that money to pay this.
Have you tried to get help through our HAWK program?
Your Honor, for the purpose of accuracy, HOP?
No, it's HAWC.
Thank you, Your Honor. ¿Ha tratado usted conseguir asistencia a través del programa HAWK?
No, nunca lo había escuchado. De hecho, yo no estoy muy al tanto de tantos programas aquí, ya que tengo muy poquito tiempo y no.
No, I never heard of that. As a matter of fact, I just don't, I'm not aware of all the programs that are available here because I haven't been here that long.
Okay. Here's what I'm going to do. I'm going to put you into a breakout room with the interpreter and Amy from the county, our court liaison officer. And she can describe certain programs that might be available to you.
Ok, lo que voy a hacer es voy a sacar un tiempo ahora para que usted le intérprete y Amy del tribunal se comunique con usted ahora aparte de la sala judicial para que ella le pueda dejar a usted saber todos los programas de asistencia que hay disponible.
Ok, excelente, me parece muy genial y muchísimas gracias.
Excellent. That's genius. Thank you so much for that.
And I will adjourn your case to May 30th, 2025 at 3 p.m. And that's an in-person hearing, so you'll have to come down to the court.
Y voy a aplazar su caso hasta el 30 de mayo del 2025 a las 3 de la tarde y para esta audiencia tiene que venir en persona al tribunal.
Ok, ¿y esa información me lo mandan por correo electrónico o directamente a ese apartamento? Ya que no vivo ahí, pues no tengo cómo sacar las cosas que me llegan ahí.
So that information, is it going to be provided electronically to me or mailed to the apartments? Because I no longer live there and don't have access to get mail there.
Got it. So you're no longer living at the address, ma'am?
Ya veo, así que ya usted no vive en esa dirección.
No, de hecho, es que la situación fue así, que una señora que estuvo en calle con sus hijos, yo le di el apartamento a ella para que ellos tuvieran tiempo mientras que yo iba para mi país a ver a mis hijos, porque como yo tengo mis hijos en una situación de migración, yo me fui por unos cuantos meses y cuando regresé, pues todo había un caos aquí con ese apartamento, pero ya yo había movido mis cosas a otro apartamento que ya de hecho, ya yo tenía que desocupar ahora en ese mes que viene, entonces yo tengo mis cosas en otro apartamento y ya que regresé, pues ya yo estoy en este otro apartamento, entonces no estoy ahí.
No, the situation is I try to help this lady that was homeless with her children. So I let her stay in that apartment while I went back to my country because my children are currently going through an immigration process. So I went for a few months back to my country and I left the lady in that apartment. When I came back, I encountered all this chaos going on. But I was in another apartment. And as a matter of fact, I have to move to another, I'll be moving to another apartment this month coming up now. So I no longer live there. I live somewhere else now.
Okay.
Your Honor, can I ask, does Jose Contreras live in the apartment as currently?
Your Honor, may I get a clarification of which apartment?
Yes.
Thank you. Ms. Jillian, may you clarify the question, please?
Let me get the address. Ms. Yoder, does Jose Contreras live at the apartment on Woodland Hills?
Señora Yoder, el señor José Contreras vive actualmente en el apartamento en Woodland Hills.
No, él nunca vivió ahí, simplemente a mí me pidieron que alguien estuviera como debajo de mí, lo que sea como para que yo pudiera sacar el apartamento, pero él no tiene que ver nada en esto, digamos, nunca vivió ahí, solamente me hizo el favor de ayudarme.
No, he's never lived there. He just helped me put his name so that I could get into the apartment, but he never lived there. He just helped me to put his name below my name.
Your Honor, if Ms. Yoder would surrender possession and we could place something on the record, I could dismiss as to her and then take a judgment as to Mr. Contreras and as to all other occupants.
Ms. Contreras, or I'm sorry, Ms. Yoder, you have surrendered possession of the unit on Woodland Hills Drive?
Señora Yoder, ¿ya usted entregó posesión de ese apartamento en Woodland Hills Drive?
Hace como un mes yo fui, hablé con ellos, les expliqué la situación y yo fui a entregar las llaves, pero ellos no aceptaron las llaves, me dijo que no lo iban a aceptarlo hasta el 1 de junio.
I went there a month ago and I explained to them the situation. I went to turn in the keys, but they said they could not accept it until the 1st of June.
All right. You will need to go over and turn in your keys Because it sounds like you are not going to be living in the premises.
¿Es necesario usted regresar de nuevo allá para entregarle la llave? Porque me parece que usted no piensa vivir en esa localización.
Sí, correcto. De hecho, yo como le expliqué, ya yo traté de hacerlo porque de hecho ya el leasing de ese apartamento ya está para este mes que entra o si no el próximo mes que entra. No estoy muy seguro, tuviera que fijarme en la fecha exacta, pero yo les dije a ellos que no iba a vivir más y de hecho yo quería entregarlo, pero ellos no me lo quieren aceptarlo. Por eso pasó, digamos, por eso estoy en espera.
Yes, I already tried to explain that to them, and I believe the lease on that apartment, I believe it ends either next month or the following month. I have to check the date. But I told them the situation that I was not living there, and I wanted to turn it in, but they did not accept it.
All right. Ms. Yoder, you're giving up your right to reside in that premises. Is that correct?
Señora Yoder, usted está renunciando a su derecho de vivir en esa localización, ¿es cierto?
Correcto, así es.
Yes, correct. That's true.
Okay. Then I will indicate that the defendant one, Ms. Yoder, has surrendered possession. I will grant a default judgment to plaintiff as to defendant two, Mr. Contreras, for possession with a writ to issue in 10 days.
Thank you, Your Honor.
Your Honor, would you repeat that again?
Okay. Defendant one, having surrendered possession, that being Ms. Yoder,
La demandada número 1, la señora Yoder, ha entregado posesión.
I will grant a default judgment in favor of the plaintiff against Mr. Contreras for possession of the unit.
Voy a otorgarle un fallo por incumplimiento a la demandada y por el demandado número 2 tener posesión del apartamento.
With a redemption, with a redemption amount of $2,775.48.
Allow me one moment while I reference a term, please.
Yeah, that's right.
Thank you. Con un importe de rescate por la cantidad de $2,775.48.
If that is not paid, an order of eviction will issue in 10 days.
Si no se paga eso, pues entonces se hará una orden de alojamiento dentro de 10 días.
Thank you, folks.
Gracias. This is the interpreter.
Yes,
Is there anything else I can do for you?
No, ma'am. Thank you very much. Wonderful job. Do appreciate your help.
You're welcome, Your Honor. Thank you for using
I am
our
not.
services. You have a good day. Bye-bye.
You do the same.
Thank
Bye-bye. I am not doing breakout. All right, that ends that block.
Thank you, Your
Thank you.
Honor.
Thank you.
You and your staff have a good weekend.
You do the same. Court
Eventually.
stands in recess. Cheryl Cornett?
Yes,
Oh, she's
Cheryl
in.
Cornett.
Okay, all right. What's name's claim this day?
With costs, Your Honor, $1,512.12.
Hey, Ms. Cornett, how are you intending on getting that paid?
I'm not sure. I've had COVID for the last 3 weeks and I'm still not right. I was going to ask if you could give me at least 3 weeks. I have a doctor's note. My other half that lives here with me, he got COVID also. So neither one of us have worked in the last few weeks. So I'm just asking if I could at least get 3 weeks.
Well, you'll have to try to work something out with the plaintiff regarding that. What I will do is I
Okay.
will adjourn this proceeding to see what you can possibly work out. I'll adjourn it to May 30th, 2025 at 2 p.m. That's an in-person hearing, ma'am. So you need to contact either your landlord or plaintiff counsel's office to see what you can work out regarding payment.
So I have to come into, this is in Chelsea, or Ann Arbor, Saline Road?
No, it's the court by the sheriff's department off of Washtenaw.
Oh, okay, okay, I'll have that, okay. All
Okay.
right, thank you. All right, thank you.
Northfield Estates versus Jason Armbruster. Jason Armbruster? No response. If you'd like to take a default, please. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Pallets Law, on behalf of the plaintiff. There's rent to retain of $3,006.99, cost of $217.80 for a total due of $3,224.79. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ to issue 10 days. Northfield Estates versus Chad Gibbs. Chad Gibbs, no response. You may proceed.
Thank you, Your Honor. There is rent to retain of $179.32, cost of $217.80 for a total due of $397.12. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with the writ to issue in 10 days. I will indicate since it's under 200, no writ without a hearing. Court does call the case, Northfield Estates versus Tamara Coppens. No response. You may proceed.
Thank you, Your Honor. There is rent to retain of $2,016.99, cost of $217.80 for a total due of $2,234.79. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with a writ to issue in 10 days. Northfield Estates versus Chris Woody, that matter is dismissed on plaintiff's motion without prejudice. Is that
And
it for you?
actually, Your Honor, my client just notified me. It looks like there were some additional payments on 2 accounts where I believe we can actually dismiss 2 of these defaults. It
Say
is
again.
Yep, the
Okay,
Chad
go ahead.
Gibbs matter, Your Honor, the 254C0671 LT, this was the default, no writ without hearing. My
Yes.
client advised that they have paid in full, so we would
Oh.
like to not proceed with that judgment and instead submit a dismissal.
Got
And
it.
same with Jason Armbruster, 669 are the last 3 on that case. They are also paid in full, and so we would like to not proceed with the judgment in that case and instead dismiss.
Okay, and matters based upon that are dismissed without prejudice.
Perfect. Thank you, Your Honor.
Thank you. Take care.
Bye-bye.
Bye-bye. Bishop Pickering versus Andrew Rich.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
Okay, Mr. Rich. He's at the access point.
Yes, he is.
Can you unmute yourself, sir, or hit the space bar? Thank you.
Hello.
Hello, Mr. Rich.
How you doing?
Okay. How much is owing?
Your Honor, I'm here.
Yes.
they got me here for non-payment of rent, but I paid my rent.
Okay, hold on. Let me see what they're claiming. Mr.
Yeah, I got my
Fantera,
receipt in my pocket.
hang on, hold on. Mr. Fantera, how much is plaintiff claiming is owed?
His current balance is $956. And he is correct that he made a payment since we filed the case, but he missed payment a couple months ago. So he's 1 month behind when he makes his payments.
That's not true.
All right, so Mr. Rich, here's what I'm gonna do. I'm gonna adjourn this to May 30th, 2025 at 12 p.m. noon. That's an in-person hearing. Why don't you bring all of your receipts to that hearing? And then you can go through them with the attorney along with the ledger and see what's been paid and what hasn't been, okay?
Right, but what I was trying to say, I get my check, my disability check on the 25th and the 26th every month. I'm always early. I never ever not pay.
Okay, all right, Mr. Rich, I can't decide that right now. That's why I'm gonna put it out a week. You bring all of your receipts, they'll have a ledger, and you can go through all of that, or we can go through it and try to figure out if you owe anything or not, all right?
Right, because I got my receipt right here for this month, and I paid it, and the same day that I paid my
Mr.
rent.
Rich, I hear you. I need you to come down next week, bring all of your receipts again with you. There'll be a ledger here, and we can go through it and try to determine if you're missing a payment.
I'm not missing no payments, no way.
Okay, Mr. Rich, that's the best I can do. We'll see you next week. Noon.
What date?
May 30th.
May, we write that down, May 30th. What time, 12 o'clock?
12 noon.
12 noon?
Yes, sir.
Yeah, they got me tripping. They got me saying I'm
Okay.
always, my rent is always.
All right, thank you. We'll see you then.
Will I be coming in person?
Yes, sir.
I would like to come in person because I'm not good with these computers.
Okay, it's an in-person hearing. You'll come right down to the court, bring your receipts, they'll have a ledger. We'll go through it.
Okay.
Thank you. Bishop Pickering versus Holly Hollis.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case is $1,539.
You said $79?
1539.
39. All right, Ms. Hollis, how are you intending on getting that paid?
I filed for SCR through M Bridges, and I've been paying on my rent every couple weeks because I had lost my job and I had, fell behind. And
okay, so how many people are in your household?
Just by myself.
Okay, so the max that they're gonna pay on that is $410. Okay, for an SER. But here's what I'll need you to do. I'm going to, first of all, adjourn your case to May 30th, 2025, 12 noon. That's going to be an in-person hearing. Okay? And you'll need to file in your paperwork, you would have seen a rental assistance form. You'll need to file that with the court by Wednesday. If you don't have it in your paperwork or can't find it, you can either use the QR code that's on our screen, or you can come down to the court and get the form.
Okay, sounds good.
Okay?
Yes, sir.
All right, thank you. We'll see you next week.
All right, have a good day.
You too. Sandy McFiddish versus Stephanie Sims.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case is $2,125.
Okay. Ms. Sims?
Here, Judge.
Hello. How are you intending on getting this paid?
Your Honor, can I interrupt, please?
Yes, go ahead.
So Ms. Sims and I spoke either Wednesday or yesterday, and what we agreed on was If she pays $400 or $500 before next Friday, then when she comes to court next Friday, I'll give her a payment plan.
Okay.
And she understood that, and I think she agreed with that.
Is that correct, ma'am?
Yes, sir.
Okay. Well, you guys are making it easy for me. So you got to do that by the 30th.
Yes,
And
sir.
then I'm going to adjourn your hearing to May 30th, 2025 at 12 p.m.
Yes, sir.
noon. Okay?
Yes, sir.
Great. Okay, thank you. We'll
You're
see you then. Have a great weekend.
You
So
as well.
when you make that payment, then give it a couple hours and then call me, and we'll figure out what you need, and I'll do a conditional dismissal. Okay?
Okay, yes, sir. Thank you so much.
Thank you. Sandy McFiddish versus Donovan Alexander.
Good morning, Your Honor. David Fanter on behalf of the plaintiff. The current balance on this case is including court costs, is $1,685.
Mr. Alexander, how are you intending on getting that paid?
I could pay it off within the next 30 days.
Okay, so you're gonna need to try to arrange something with the plaintiff. How much can you pay before next week?
Up to $500-$600.
Okay.
Your Honor,
So you need to you need to pay $500 to $600 by the 30th.
By the 30th.
And if he does that, I'll give him what he needs on the balance.
Okay. All right. So get that paid. I'm going to adjourn the hearing to the 30th, May 30th, 2025 at 12 noon. Try to get that paid like the 29th if you can. And then when you come into court, it'll be something where you might be able to arrange so we can get you caught up, okay?
Okay.
All right.
Okay, yeah, okay. Thank you.
All right, thank you. You have a great weekend.
You too.
Sandy McFiddish versus Jalea Thomas.
Good morning, Your Honor. David Fancher on behalf of the plaintiff. The current balance on this case, including court costs, is $2,325.
Ms. Thomas, how are you intending on getting that paid?
I'm working on getting in contact with Hawk Housing Assistance for Washington County. That's the best thing I have right now. The house wasn't in the best living situation or suitable situation for me and my child. I asked to be released from the lease. It didn't really work out that way, and so I actually moved. So I have to work out getting the money to them.
Okay, so hold on. You moved out of the premises?
Yes, I left April 15th.
Okay, did you turn in the keys?
The keys were dropped off, yes, yesterday.
Yesterday? Okay, here's what I'm gonna do. Because they're requesting only possession of the premises. You still may owe the money. Hold on. But you still may owe the money to them. But this case is for possession of the premises. So if they can verify that you turned in the keys, this case may go away. Okay, you still may owe the money, but.
Ms. Thomas, who did you give the keys to?
I was asked to give the keys in the mailbox for maintenance. Well, it wasn't maintenance, but for the leasing officer, like my property manager for that place.
So is the apartment vacant?
Yes, it's been vacant since April 15th.
You've got everything out of there?
Yes.
Your Honor, I think with that representation, and there's nobody else living there, correct?
No, I actually had been asked to get let out of my lease due to plumbing issues, and they wouldn't try to let me. They tried to make me stay until July.
All right, well, we can figure that out later. But Your Honor, I think I can just dismiss this case based upon her representation that she's out. And
all right,
even if we can't find the keys, I think we can take possession.
No, that's not the picture. I can actually bring it, but there's a picture of the keys in the mailbox at the place.
Okay. You surrendered possession on the record here. They're going to dismiss the case, and they're going to take possession of the. Okay.
Okay.
Thank you.
No problem.
YPF 16 LLC versus Frenchie Alexander.
Good morning, Your Honor. David Fantair on behalf of the plaintiff. The current balance on this case, including court costs, is $1,350.
Frenchie Alexander, no response. If you'd raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go
Your
ahead,
Honor,
sir.
I'm David Fantair. I'm the attorney for IPF 16 LLC, and as such, I'm familiar with the books and records as they relate to this tenancy. In this case, there's rent owing in the amount of $1,175, court costs of $175 for a total of $1,350. We'd ask for a judgment for possession with a written 10 days if that amount remains unpaid.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested. Writ issue in 10 days. 103 South Heron LLC versus Aaron Emanuel.
Good morning, Your Honor. David Fantair on behalf of the plaintiff. The current balance on this case is $2,215, and he's already been approved for money from SOS for the full amount. So I think if we just come back next week, we can do a conditional dismissal. Maybe it'll even be paid by then, but even if it's not, we'll just do a conditional dismissal and resolve it.
All right, Mr. Emanuel, is all of that okay with you?
Yes, sir.
Okay, you guys made this easy for me. I'll adjourn this matter to May 30th, 2025 at 12 noon. Okay, we'll see you then, and hopefully we got everything worked out at that point.
Is that in person?
Yes, it is, sir.
Okay.
All right.
All right.
Thank you.
Thank you.
And you know, Your Honor, I've made life tough on you sometimes, so I guess I made up for it at least a little bit today.
That's right. It balances out. All right.
I'll see you this afternoon. Thanks, Your Honor.
All right. Thank you. Thank you, Mr. Emanuel.
Thank you.
That's it for that block. Court stands in recess. Come on.
Philip speaking for the plaintiff, Your Honor. Alexander, on behalf of the defendant.
Good afternoon, Your Honor. Lauren Lehman for the plaintiff as well.
All right. And where are we? I hate to ask.
No, so we had inspections on 5/20, the COC inspections. There were a number of items that we noted were failing for the inspections. They were supposed to come back out on 5/22 for reinspection. That was what we discussed at the pre-meeting. Property essentially they have to collect some items. And then we will be here on the 23rd to discuss where we are with COCs. Nobody showed up on the 22nd. We had guys there waiting for the reinspection, ready to go. Nobody from the city showed up to do the reinspection. So that's first and foremost at this point. I'm not sure. We were provided no notice as to why they would not be there on the 22nd. We were expecting that to occur. So our guys are ready with items having been corrected from the original list. From what they noted on the 20th, and nobody from the city showed up on the 22nd.
Anybody know why they didn't show up on the 22nd, Mr. Parker?
Your Honor, the inspector was standing in Carol Kunke's courtroom yesterday with counsel. He knew exactly why I wasn't there. Because there was a laundry list of not callbacks that we didn't have. Judge Kunke has entered orders or will be entering orders, we think, this morning, addressing the repair and inspection protocols for all of these buildings, because she's some jurisdiction over all of those. But we were called back out to say, this is fixed, now look at that, this is fixed, now look at that. We're going to continue to do our inspections, consistent with what we've agreed to do, and consistent with what we've been ordered to do by Judge Kunke.
I was in court. Joe and Myers and Gary Dunham were in court as well. I know that the city has other inspectors. We were expecting an inspection to occur. We had guys ready. We had no reason to know that they were not going to show up. We didn't know Jerry or Joe were going to be in court. I don't know what that there's no reason for them not to have showed up. I didn't notice that they weren't going to show up or to not arrange for other inspectors to come to the property to inspect, as we discussed.
All right. So I guess I want to make sure, and maybe I'll call, touch base with Judge Conkey. Is she issuing an order
So,
laying out everything? Because then I don't want to interfere in any of that.
so Judge Conkey is entering an order, based on what she explained on the record. She will be entering the order that repairs be done at the property. Basically, as urgently as possible, get the repairs done. She will be entering an order, with regards to, tenant requests for relocation, things of that nature. Obviously, we don't know exactly what it's going to say, but, you know, this is what she indicated on the record. And as well as, you know, instructions to the city for timing of inspection. She, you know, took some issues with that. So she's gonna require the city to inspect within 2 days of a request. And also, you know, make themselves reasonably available, for inspections if they're already on site or something, to inspect other work that may be ready. So she's gonna be entering orders to that effect.
Do we know when she's going to do that? Or did she?
That we would possibly have a draft of that order at minimum today to see what it would look like. I think she's waiting on 1 or 2 exhibits that ourself and legal services are working on in connection with that. I know I spoke with Lou about it, so I'm not sure.
Yeah, we're working on a draft that we should have over by, you know, the end of today, and either today or I think next week she's planning to send out that order based on our draft and possibly yours that you send in, which will be covering, you know, what she's dealing with in terms of focusing on repairs, as well as how tenants might be able to get relocation assistance, from their escrow amounts, with the city, as well as whatever they paid to the landlord, since September 17th, so that they can use that towards relocation for the tenants that are still, you know, in the property.
All right. So what I guess I would want to make sure of what's contained in that order, because we have, this court has escrow funds.
Right, so one of the items that will be in the agreement that I think is pretty undisputed at this point is that Arbor One will not object to the release of the escrow that's being held by the city or the court. I believe that the city's agreement requires that like all parties agree to some extent, so, or something of that nature. So the order will clearly say that if they're electing the remedy to break their lease and move from Arbor One, that we won't object to those funds being released so that they can utilize that in finding whatever housing they may want to find.
Okay, so that will be contained within the order.
Yes, that will be involved with the order.
Okay, so what it seems like to me, and I guess what I'm gonna do is I'm gonna pause and I'm gonna try to reach out to Judge Conkey directly and just see exactly what she's doing, because if she's going to assume all of this, there's no reason for 2 courts to be doing it, in my opinion. So
to the extent that there are folks on your docket that have been relocated, so one of the things that she indicated is folks that are being relocated are going to be paying half of their rent. I know that that's something that
paying half of their rent,
or what it would have been in Arbor One. So if folks are being relocated with the intent to come back to Arbor One, so temporarily relocated, basically saying, I want to come back to Arbor One once I can be placed in a building with the COC, those folks are being required to pay half of their rent during their relocation period.
I don't think that was part of this initial order, but she did bring that up as a possible thing she was considering in the future, and bringing up those issues of tenants relocated to the hotels. We did have Mr. McGuire, who was relocated to the hotel, and it seems he's been relocated back to his apartment.
Okay, so I guess I'm curious. So where would, and I realize you don't have the order, where would this half rent be paid?
To Arbor One. And so basically the argument was, you know, if we're relocating folks to a place that has a COC, whether it's, you know, whatever accommodations are ultimately determined, Judge Kunke found it reasonable to say that they should be paying half of their rent. And so I believe that it is going to be in the part of the order. The last part that we talked about, no order, so that there's no direction to relocate folks, or something in the order that says folks can request to be relocated but have to pay half their rent. So I believe that she decided that was going to be a part of the order, so it's going to be in there. I bring it up, and I know that this is something we talked about last time with folks that were on your docket having been relocated, establishing whether or not they intend to stay. And at that point, we should be discussing leases with those folks, or if they're planning to come back to the city side. And if that's the case, then they would be subject to that part of the order. So we just wanted to advise the court that that would be something that would be happening with those folks.
Okay. So for individuals, I'm just thinking about the cases that are before me. So for those individuals that relocated coming back, they would be, let's say their rent's 1,000, they would have to pay 500 to Arbor One.
Correct.
What happened? So, okay. What happens with the other piece?
The other piece of the rent.
Yeah, it's just not paid.
That is, I think that is just taken as a loss to Arbor One. I think the idea is that.
Got it.
Yeah, so it's basically everybody's paying half. That was the.
And I think it'd be specific to their portion as well, too. If they're subsidized, they pay half of their portion, whatever that is.
Got it. They pay half of their portion. What happens with the subsidy?
I don't know if it was fully addressed.
Got it.
That's not something we got into.
Okay.
Up to the tenants.
Subsidy counts the hotel.
So I think what I will do, and so I could make this a very short hearing, it seems. Because it seems to me that if she's going to do all of that, that I'm not going to do anything and wait and see how it affects the cases that are before me. With reference, so for example, just taking by way of example, the escrow order. That really, I think in some ways negates the escrow order, right? For those individuals that would fall within that classification. Would you agree with that?
It negates your escrow order.
Yeah, because so if an individual is intending upon coming back, what the circuit court is saying, they need to pay half of their rent to Arbor One and Arbor One West. My order would indicate that they pay nothing, that they pay everything to the court.
Right, so yes, in essence, it would negate that, and then for the folks that are leaving altogether, they would get it back. So yes, in essence.
So of the cases that I have, how do I sort those people out?
For the folks who have been relocated versus, so we don't know the extent of everyone's desire to be relocated or staying permanently or temporarily. Some folks have also found their own housing at this point. So I think we would need to get a list of folks that have been relocated by Arbor One and, connect with them about, to the extent they intend on staying where they are, or if they are intending to come back to the city side. And if they're staying where they are, then we can deal with leases. And if they are intending on coming back to the city side, once there's a unit available that has a COC, then they would be required to pay their 50% of rent.
And do we have any people still in hotels that were relocated to hotels?
It's my understanding nobody is still in a hotel.
Okay,
Everybody's been relocated somewhere else.
I believe Mr. McGuire was relocated back to his original tenancy.
On the
So
city side?
I believe so, yeah.
I can inquire into what's going on there. I don't know why it's back, what's happened there, but inquire and get the court information if that's what you're looking for, Your Honor.
Well, I just want to make sure that the 42 I have, that the orders that are consistent with what's been ordered at the circuit court. That's what I want to make sure of. And I guess we can do that sort of on a continuum basis, or what I could do, and what I may be inclined to do, is to just issue a stay on these proceedings before me, and just await the final resolution in circuit.
Our next visit with Judge Connie is on
The 9th of June.
In lieu of a stay, could we perhaps adjourn proceedings for, say, 3 weeks to see we can sort everybody out? Who's gonna do what, when and where, and then we can maybe get some dismissals or CODs or settlement agreements in place?
Something in place
Yeah.
on these. That's fine with me also.
Okay.
I don't have a problem with that, as long as the repairs are being made and the tenants. It sounds like through what Judge Kunke's doing, the tenants are being taken into account in terms of what's happening. So,
I think a stay might work better, because I just don't know how long this stuff in circuit court's gonna go on for. But I think, once that's over, it's mostly gonna resolve any issues that exist for all these tenants, in this report, I believe.
well, why don't I do this? Why don't I adjourn this out to? Do I have I have the 27th?
27th of
June.
June?
Yeah.
Yes, sir.
All right. Why don't I adjourn it out to the 27th of June at 11? All right. Allow that to kind of take place if necessary, and then do that. All right.
Good. Thank you, Your Honor. In lieu of you having to bring your staff out on the 28th, I have a pamphlet showing a lot of
the
Yep.
things. All right.
So what Mr. Whitman is providing is photos taken of units in both of these buildings. At this point, we're dealing with situations where many of these units are ready to go, turnkey, ready. There are remaining items on the correction orders list, but not necessarily because they weren't corrected from the original list, but upon inspection, the city added more items to the list. And so we're obviously, you've made your decision with regards to having Kunke overhear this, and so, we're gonna be arguing that these buildings are ready for the minimum temporary COCs. There's no reason that folks should not be in those units, and, a correction order for the units that still have some items that need to be done. List be provided of a 30-day correction order. These units are not to be occupied until corrected, and a temporary COC provided for the building. At this point, we need to get folks in these units that are ready to go.
But did Judge Kunke address the issuance of the temporary CEOs?
We did talk about it. She, at some point, it's been discussed. We didn't get it very clear. Seemed at some point she was inclined to an interim solution inside of, asking about the units that were ready to go. I don't think that we were able to explain to her that we would request a 30-day, correction order for some of these items that, the temporary COC could be in place, and that the correction order could say that some of these units should not be occupied until those items are taken care of on the list. But no temporary COC was ordered by Kunke at the time, but we also have these photos as of today. And so we're going to be presenting her with this same information, that there's no reason folks shouldn't be in there we're talking about items in some of these units that folks recently moved out. One of the things we talked about at the meeting with the city was that, what do we do if you come out for inspection and somebody moved out of their unit, 5 days before? Are you gonna ding us because we're still turning that unit? A lot of these items that have been presented to the court, in the most recent submission by the city are in fact some of those units and issues that we're still waiting on inspectors to come out and inspect. We still have inspections scheduled out for a lot of these units. So these items are not things that should hold up a COC or a temporary COC getting into the building. These items can still be corrected and it can be ongoing while folks are able to be in these units that are perfectly fine. All right.
Okay.
There we go.
So what I will do at this point is I will cancel my visit on the 28th to the unit, given these being here. And also given the fact that it seems, again, I don't want to interfere with what the circuit court is attempting to try to do or try to do something that might be inconsistent with that. I think it's going to cover. It sounds to me, based upon what's being explained, is going to cover in the same way that I would the cases that are before me. So. Okay.
Thank you.
So what I'll do is I'll adjourn this out to June 27th, 11 a.m. for a status conference.
And then for the tenants in this board, should they continue to pay escrow for June?
They should. Yes, they should pay their escrow for June. And then, because as I understand it, given what that order circuit court may look like, depending on then what that tenant decides, there's going to be some disposition of that escrow. All right.
Thank you, Your Honor.
Thank you, Your Honor.
The other aspect to it is, and I'd rather not refund it because it was the only way we were able to at least start the inspections. We still have that 65,000, I think it is, sitting here.
Okay.
And that, I mean, the intent of that, as I'm recalling, was to pay various invoices of the city regarding some of these inspections. So
I guess that be turned over to the city.
well, that was the problem before. You want that turned over to the city, but when we tried to do that, we were told couldn't do that. They didn't want to just take a lump sum.
It would have to be applied to individuals.
Right, but nobody knew what those were. And so.
Why don't I suggest this? I can, obviously a holiday, but, we have to figure out what we're gonna do with our escrow too, obviously. Have the, Mr. Myers break down the list, submit that list to the court for what costs go where, that might be the approach.
I mean, from our perspective, we would have no objection to the money just being applied to inspection fees. I think that that's been the biggest kind of holdup in getting some of these things done. And I think that that would help expedite making sure that things are done.
Right, no, so if anybody recalls the hearing, the sole reason that money ended up here is because there were these inspection fees due, and then there was an indication that further inspections weren't going to be done because these others had to be paid. And then I had to go through and try to figure out what the amount was that needed to be paid. And then I got a figure which was opposite of what I thought. I actually got a lower figure from the city than I did from Arbor One as to what was owed. So I took the higher figure, said, put it in escrow. Now it's there. When I also suggested that they just turn over the lump sum amount, that was sort of rebuffed because it was said, as I'm recalling, that they, whoever they are, don't like us to take it that way, that it has to be applied. So I don't have a problem if the city were to get to council get together while this is going on and come up with a list of what invoices are to be paid. Give me a total at the end that's then to be released to the city. I don't have a problem with that, but everybody just needs to be in agreement what needs to be paid.
For the record, I think your recollection is accurate.
Thank you. Still haven't lost it, I guess. All right, so if you guys get that together, give me an order for release of that. I don't have a problem. I just didn't want everybody losing sight that that's still sitting there. Okay. Thank you, folks. 27th at 11. Thank you. Court stands in recess. All rise.
That makes it a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a family disturbance call. Law enforcement officers made contact with the complaining witness, who was the defendant's wife for 15 years. The law enforcement officers could hear the defendant yelling inside of the house. Law enforcement officers detained the defendant. The complaining witness stated she was shoved by the defendant and fell on a chair, and that the defendant then stated he was going to punch her with his fist, and that he was punching his own hand in a threatening manner. A witness, the defendant's son-in-law, stated he heard the defendant threaten the complaining witness and saw the defendant punching his own hand in a threatening manner.
What was again?
The threat, the defendant then stated he was going to punch her with his fist and that he was punching his own hand in a threatening manner.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with your case. I see that we have a prior assault from 2024 and 2 prior VPOs, and I'm trying to see if they're all with the same complaining witness. I see the assault is the same complaining witness. 1 VPO is no, now's not the time.
Judge, we can see on our end, they are all the same claims.
Okay. Mr. Rodriguez, I want you to understand something and let me make it clear to you. I'm going to protect every person in my county. I don't care who they are, what color they are, if they're a small farm animal. I will protect every single person. And if you become a danger to my community, I only have one place for you. Do you understand me?
Yes, sir.
I don't want you to have any contact with the complaining witness in this case, and I'm gonna put a monitor on you so I know where you are. I don't want you to go within 1,000 feet of where she lives or where she works. Do you understand?
She's my boss. She hired me. I work with her. She's the GM.
I don't care what's going on. All I want is my city protected. And
Yes,
the
sir.
idea is that I don't want you to have any kind of run-ins with her. You guys have words and then something drastic happens. And I'm trying to prevent
Yes, sir.
something nuclear from going down. The best way to do that is to keep you guys away from each other. Do you understand?
Yes, sir.
If you have cancer, you cut it out. Otherwise it kills you. Sometimes in your life, you have people who are a cancer to you. And if you don't cut it out, you end up in custody with a very main sentence. This is now your 5th case regarding the same person. Do you catch my drift?
Yes, sir.
All right. Do you have the ability to hire a lawyer?
No, sir.
I can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. I also don't want you to be in possession of weapons.
No, I don't have no
If you qualify, I'll give you a lawyer today, but I'm telling you now, I don't know who you have in this world, But if I find that you're a danger and I have to make your bond $10,000, $15,000, $30,000,
Yes, sir.
you don't have anyone to pony up, you'll be stuck like Chuck. You understand?
Yes, sir.
Come on.
All right, Judge, next, April 26th, Williams, come on up.
Good morning, Mr. Williams.
Good morning.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers observed a motor vehicle with no front license plate. A traffic stop was conducted. Law enforcement officers made contact with the defendant and observed a strong odor of marijuana. The defendant stated to law enforcement officers that he has a handgun in the vehicle. The defendant admitted to having smoked marijuana in the car previously. The law enforcement officers located the marijuana and a handgun inside of the defendant's motor vehicle. The marijuana weighed approximately 55.7 grams.
Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. You mind running his license, please? I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand?
Yes, sir.
If you do not have a license and liability insurance in your name, you're not allowed to drive, and that is also a bond condition of yours. Do you have the ability to hire a lawyer?
Yes, sir.
We're going to give you time. I will have you go to Victoria, sign a reset. After that, I'm going to have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Don't pick up any new cases.
Yes, sir.
Your Honor, his license is eligible.
Great. Okay, please. So do you mind finding those conditions, please?
Yes, Your Honor.
Sign for your reset. Judge, this last one, I have a case number for you.
Okay.
2561239. This one was an arraignment from yesterday that fell to here. It's
Okay.
here today.
Ms. Joya, come up. Why did you miss court, ma'am? Sorry? When you don't come to court, we issue a warrant and you end up going to jail. I'm going to reinstate your bond, but I'm not going to do this again. The next time you miss court and I have to issue a warrant, you will go to jail. Do you understand me? No more get out of jail free cards. This is it. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one, ma'am. Okay.
Thank you, Your Honor. On April 21st, 2025, in Harris County, Texas, law enforcement officers were dispatched to a shoplifting call at JCPenney and made contact with the complaining witness, a loss prevention officer. The complaining witness stated the defendant entered the store and placed 2 swimsuit sets in a black purse, then passed all points of sale and exited the store. The total value of the merchandise was $144.
This is the co-defendant to yesterday's theft, right?
That's correct. Yes, Your Honor.
Okay. Ms. Joy, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go back to JCPenney and not to be in contact with the co-defendant in this case. Do you understand? What do you do for a living? Did you graduate from high school? I'm sending you now for a drug test. I want to know if anything is in your system and you're to come right back. You're 18 and you have nowhere headed. That's not a good way to go through life. You know, you should never, ever have to depend on anyone, and you need to be a strong person to be able to work and make money. Because in this life, if you don't have money, this life sucks. And you're 18 and you're headed nowhere, where you're going to end up being dependent on someone. That's not a way to go through life. You need to get into school, get knowledge, so you have a good job, so you can support yourself, so you don't have to rely on anyone, much less a man. Men suck. Don't rely on them. Be a strong woman. You understand? Okay, I'm sending you for a drug test. You're going to come right back, and I'm going to appoint your lawyer today. Just take a seat for a minute.
Can I get her to sign real quick?
Yeah.
Definitely cute.
This is on Mr. Rawlhawk from yesterday.
Okay.
What bond conditions did you want for him?
I do want a GPS monitor.
Okay.
And I want him to stay at the house. Actually, guys, could you bring up Mr. Rollhawk, please? How's jail?
Better be out. That's for sure.
You're giving you the opportunity, but I will not do this again. If you pick up a third case, I'm gonna lose it. Do you understand me?
Yes, sir.
Want my streets safe, and I will do everything in my power to protect them. Your lawyer has worked hard to find you a place to go to, and I expect you to go there. I'm putting a monitor on your ankle so I know where you are. You are expected to go there and be there every night by 9 p.m. Do you understand?
Yes, sir.
If you deviate, if you pick up a new case, if you are a danger, if you don't go back to this place, then I'm going to revoke your bond, put you back in, and you now know no one in this world is going to give you a bond. So you will be stuck in there until these cases are over with. And I don't accept pleas of guilty just to get out. Do you understand?
Yes, sir.
This is the one opportunity that you have. Make the most of it. Anything else that you think that we need? Are you taking any medication at this time?
I have not taken any medication.
Or should you be? Have you been diagnosed by a doctor? Have they told?
That was years ago.
Okay.
So it's been a while.
So when you get out, what are you gonna do? What are your plans?
Still, this is house, correct? Okay. The idea is to get my ID back and then to be able to find a format of employment.
So this is a great goal to have. and we're going to make sure that it happens. So I'm going to set you off. I'm not going to blindly reset with hopes that you do it. I'm going to keep you close so I see that you actually do it. When you have too much time on your hands, you become self-destructive. So you need something to do. And working is the absolute best because it keeps your mind occupied so you don't start doing things you shouldn't do. And the best thing about it is you make money.
Hey, that's true.
So I'm going to give you 2 weeks and I want to see what you have done to get your ID. Go home, wash the jail funk off you, dress up nice, go get your ID. If you do that, after that, we're going to give you a month to try to help you get a job.
Okay.
Do you understand?
Yes, sir.
Okay, none of this just all day. It's not going to happen. Do you understand? All right, make me proud. Thanks. Ray. Hey.
I have Mr. Montanez.
Okay.
Statement and update. I'd asked the state to eval it. They've done that. They made an updated offer this morning. Just need to talk to him, see what he wants to do. Get him in here, see if he.
What's happening upstairs? Do you know?
I don't think he has a case upstairs.
Janiel Montanez?
Yeah.
Yeah. Do you see it? Oh,
Oh, it's
I'm
here.
sorry. They're
Here.
both here. I don't know why I was thinking of something. Okay.
I think that's a fair assumption.
Well, no, I was thinking,
It's-
is it going to be something writ court, like related?
No, it's a plea to the DWI and dismiss the PCS.
Okay, it's 140. You want a standard reset?
Yes, sir.
Okay, so at the next setting, let them come back here and then we'll,
Perfect.
yeah, okay, thanks.
Judge you said required?
Yeah.
Oh,
Yeah.
Required, right?
Yeah.
ready?
Hey, please.
Your attorney?
Hey, good morning. Who do you have?
I have Mr. Hostler, Judge. It was reset for bond forfeiture today from last week.
Here?
And I've texted him, called him.
Okay, yeah, not a problem. We'll revoke it. With the J, right?
Jay, yes, sir.
And do you want to withdraw?
Yes, please.
Okay.
I called that last week.
Got it. All right, I'll sign it and then
And we do have, I have the copies of the text messages where we've sent him.
I trust you, you're an officer of the court. right?
Thank you, Judge.
So 5,001 by the end of document. Okay,
Thank
just
you,
follow it
Judge.
and then I'll send it.
Yes, sir. May I be excused, Judge?
Jostle with a J. It's page 14.
Okay.
Yeah, okay.
May I
Thank
be
you, Mr.
excused,
Simon.
Judge?
Yes, sir.
Thank you, Judge.
Judge, we have another arraignment that came in just a little late. Are you ready?
Yeah.
Page 11, Green, come on up.
Francisco.
Does he have a warrant for his arrest? Felony warrant? You guys check.
What was his last name?
Green. What time did you get here, Mr. Green?
I think like 9 o'clock, a little bit before, but I didn't know the COVID.
You come late and you come in shorts. Is this a good way to come to court? It's a complete lack of respect. And if you do it again, I'm going to put you out. Do you understand? You are charged with criminal trespass. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 22nd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a suspicious person call and made contact with a law enforcement officer working an extra job that stated the complaining witness approached him and stated that her phone was stolen from her front porch by the defendant, who she ID'd and provided a description of. The law enforcement officers found the defendant, who fled inside an apartment and then was detained. Law enforcement officers found the complaining witness's cell phone in the defendant's front jean pocket. The defendant had a prior trespass warning for the location from January 2025.
So you go inside that. Ab?
Yes, Your Honor, we just have here that the complaining witness stated her cell phone was stolen from her front porch.
Mr. Green, I'm gonna find that there's probable cause to go forward with your case. I'm now sending you for a drug test. I want to know what, if anything, is in your system, and you're to come right back. Do you understand? Right. Do you understand? I'm also going to put a GPS monitor on your ankle, and I'm ordering you not to go anywhere near this apartment complex. If I find that you do, if I find that you're a weapon, that you have a weapon, if I find that you're a danger to my community, I will revoke your bond, and I'm gonna make it sky high. You are on felony deferred for a very serious case. Does he have a felony warrant? Why is this showing no bond?
I'm not sure, Judge, but I don't see it.
Take a seat for me. We'll have you sent in to see you 15 minutes, 20 minutes. Did we do a TRAS on this?
Yeah.
What did the TRAS say? Lopez. Page 44. We did do a TRAS. I mean, it doesn't even matter though, really, because she's got the delivery case upstairs, so anything that we wanted to do, it's.
It said, the recommendation was school A.
Hopefully they address it upstairs. We just can't because of the open case. Ma'am, you were charged with prostitution. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 51 days in jail with credit for the 17 days that you have done. You need to understand that this is going on your record and it's going to be there for the rest of your life. You need to understand that if you continue to pick these up, at some point they can hit you with a felony and you're looking at years instead of days. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. There's no changing this. Is this what you want to do?
Yes, sir.
How do you plead to the office, ma'am?
Guilty.
I find you guilty. I'm going to follow the agreement. Good luck to you, man.
Thank you.
No, I just want to talk to you specifically robustly. Robustly, we're gonna have a robust discussion. What? Yeah.
Why does this keep happening? Over and over and over. Why does this keep happening? How many cases did you have last year, Mr. Addison?
I have quite a few, sir.
Now you pled on the 17th of December, and not 3 weeks later, you have now another criminal trespass. How do we stop this from happening?
You need to leave Texas?
No, we don't want you to leave Texas, but we want this to stop happening. Why would I keep doing this?
Officers don't like me out there, man. They be harassing me. They beat me up. They assaulted me. They put me in the hospital. They tried to kill me.
So why go back?
What do you mean?
Why go back to the same location over and over if you know that they're gonna beat you up?
I'm in the state of Texas, not just this area. The state of Texas, the laws don't like me. The police don't like me, sir.
That's baloney because you're a likable guy. We all like you, Mr. Addison. You seem like a stand-up guy, get nice, but You keep going back. Why would I keep doing this? You know, we hit you with the time served. We let you out. 2 weeks later, you pick up a new case. And it's been like that for the last damn year. Where's your family? Who do you have in your life?
I don't have nobody in my life, sir. All my family is dead. My twin just died not too long ago.
You ain't got no kids?
But they grown here, but I can't find them.
Why not?
Because their mother hid them from me.
You ever tried to find them?
Yes,
How?
through the internet. Through the internet, sir.
I don't know, Lori. We're doing the same shots over and over and over. And last year, 1, 2, 3, 4, 5, 6, 7, 8, 9 cases just last year. You pled at the end of December. January, you've got a new case. We let you out. You took off on us 2 more times. And the only reason we have you now is because you picked up an interference. And now we're doing the same thing over. I'm not going to do this. I'm done, Mr. Addison. I'm not going to continue to do this. Plead you to the time served in hopes that you're going to go out there and not do it. No, it's not going to happen. We need to figure something else out. Thank you. That's very sweet. But I'm not going to do this. We need to do what I'm going to do now, what's called a TRAS, to see how we go forward. Because I don't know enough about you and what's going on in your life to figure out how we go forward so you stop picking up criminal cases. I told you that many moons ago that I'm going to stop doing this. And now is the time. I'm not doing it, Mr. Addison. We will set this case for a TRAS. I'm going to try to expedite to get it done as fast as we can. I'm done. What I'd like to do, and the hope is that somehow you, me, and Lori can figure out what kind of family you have in the United States so that we can get you somewhere where you stop getting in trouble. But it's not working what we're doing. And I'm not going to continue to, this is not a revolving door. Do you understand, sir?
Yes, yes, Your Honor.
That's what we're going to do. So Lori, I'm sorry, but let's set it for a TRAS and we'll come back next week. Good morning, Mr. Is it Heron?
It's Heron.
Heron? Ms. Heron, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Judge. This one was a 2B. On September 28th, 2024, a law enforcement officer was dispatched to a family disturbance at a residence in Harris County, Texas. The caller reported she observed the couple arguing in a truck, children crying, and heard a loud bang as if someone got struck in the head. The law enforcement officer observed the truck with one functioning headlight, matching the description that was given him regarding the truck. The law enforcement officer observed a juvenile outside of the truck with red puffy eyes. The law enforcement officer made contact with defendant 1, Ms. Heron, and defendant 2. The defendant stated there was no altercation or arguments that occurred and that the law enforcement officer was talking to the wrong people and that they were okay. The law enforcement observed an odor of marijuana. The defendant's vehicle was sitting outside of a random residence at night, and the defendant stated the vehicle belonged to a friend.
Which defendant? Who?
I just said the defendant stated the vehicle belonged to a friend, and then there's defendant 1, which is referring to Ms. Heron for the next sentence. Ms. Heron refused to ID herself and stated she was going inside of the house. The law enforcement officer told defendant 1, Ms. Heron, to stay put until the conclusion of the domestic violence investigation. Defendant 2 exited the vehicle, stated, "No, I am not," when advised, and he was detained and pulled up his pants before getting in a bladed stance. The law enforcement officer grabbed the defendant 2's right wrist. Defendant 2 pulled away. The The law enforcement officer grabbed defendant 2's shirt, telling him to stop as they fell to the ground. The defendant 1, Ms. Heron, pulled the law enforcement officer's arm and pushed the law enforcement officer's chest, preventing the law enforcement officer from restraining defendant 2. The law enforcement officer took out an electrical conducted weapon, told defendant 1 to get out of the way, Ms. Heron, and defendant 1 continued to refuse and push law enforcement officer's chest. Ms. Heron ID'd herself with her name and date of birth, which was confirmed with the Texas driver's license.
Ms. Heron, don't, now's not the time. You know, I've got a bunch of DAs here. Whatever you say, they're going to use it against you. You will have the opportunity to fight your case, just now's not the time. I'm going to find that there's sufficient probable cause to go forward with the case. Do you have the ability to hire a lawyer, ma'am?
I don't.
Okay, we can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you, how much money you make, what kind of job you have, and then we'll take a look to see whether you qualify. I see that the co-defendant in this case has a valid warrant for his arrest. I think that there's still a warrant open for his arrest. Also on a felony warrant as well. I'm ordering you as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? If you do, I'm going to put you in jail. No more PR bonds for you. Do you understand? Okay. So Deputy Miranda is going to give you an application. I'm going to have you go to Victoria, sign and reset, and then we'll have you take your seat in the jury box while you fill it out. Okay? Please. Can you file?